record, which I forgot to do. And anyway, I'm going to start by sharing my screen. You can post questions in the chat or feel free to speak up. I'll try and leave some time briefly afterwards. And this will be available to you as a reference tool for the remainder of the academic year. So here we go. Excuse me a minute. Okay, I apologize. I'm having problems sharing my screen right now. Just bear with me, please.
Maria, I think you have your microphone on. Would you mind putting yourself on mute? Thanks.
Oh, okay.
It's on the bottom left corner of your screen. Yep, we got it.
Okay, just give me 1 second here. I've got a screen in my way. Sorry, 1 sec. Okay, apologies again. So I'm going to go through this. Please bear in mind that this will be available to afterwards. You don't need to make a note of everything that's here. I'm going to start by saying something very important, and that is, Milan, a lot of people fully understand copyright, and I think that's a pity, because it is, I think, essential to your career in any number of ways as a visual artist, and it's much easier to correct problems with copyright if you know a lot about it first, or more about it first. So what is it? It's the exclusive legal right to produce, reproduce, publish, or perform an original literary, artistic, dramatic, or musical work. And copyright offers you control over how your work is used, and in order to protect its value. So that others who want to use the work have to get your permission or an assignment of rights. before they can use it. So, and you can see there that excuse me, it covers any number of definitions as to what is protected under the Canadian Copyright Act. Oh, come on. Sorry, some glitches here. Anyway, okay. Generally, the creator or author of a work is the first owner of copyright, and so any work that you create originally is automatically protected once you've created it. You'll see the word author, creator, or copyright holder or artist used interchangeably. You can choose to register your copyright or to mark your work with a copyright C symbol, but it's not required, and it's really not of any value because it doesn't particularly protect your work in any greater way. So also important to understand that ownership of an artwork does not necessarily mean that you own the copyright. In other words, if you sell or I sell a painting, whether it's through a gallery or whatever method, that person owns the physical work, but they do not own the copyright to it or the intellectual property. In other words, they do not have a right to use that painting or that work to make financial gain, nor can they use it publicly, publicize it without your permission. So what does copyright apply to? So it covers covers tangible expression of an idea in some sort of fixed form, in order to be original. So the terms of protection depend on what country you're in, but generally 50 to 70 years after your death, until 50 to 70 years after your lifetime, something that you create is protected by copyright. But it doesn't apply to an idea for a painting or the title of an artwork. For instance, this work by Tom Thompson, the Jack Pine, and it actually doesn't apply to that work, which is because his death is over 70 years ago. Obviously, it is now in the public domain, and there's no further copyright protection for it. I'm sorry, I'm having trouble moving from slide to slide here. But here we go. It seems to work after a minute or so. So there are several ways in which copyright can have an economic impact on your career as a visual artist. And you have to be familiar with the following rights. First of all, the exhibition right, the right of reproduction, and potentially the artist's resale right, although that isn't law at this point in time.
Oh, Patty, I think we have one or two people in the lobby if you want to just quickly check that.
I'm just going to do that. Sorry, I just see it on my screen now. Just a second, if I can get there. come on. I really apologize that something has gone wrong here so that my mouse is not responding, my trackpad isn't responding to any of this. So I apologize.
Hey Lou, looks like your mic is on. Can you turn it off, please? Thanks.
For those of you in the waiting room, I apologize. Excuse me, I'm going to stop screen sharing for a second, folks, just to figure this out. If I can.
I think we also got one more in the lobby right now.
Yeah, I'm just trying to, this is really screwed up. I'm just trying to navigate here. Okay, I hope that's better. Sorry in advance. Those three are exhibition, reproduction, and the artist resale right. The exhibition right is probably the most important one from a career point of view. Many people do not realize that when you're paid a fee to exhibit your work in a public space, that is actually a copyright fee. It's a license to show your work in public that is paid to you by most galleries, and it was set out in the Copyright Act, which provides an exhibition right. Now, that doesn't dictate a fee. It defines what uses are subject to the Act and what permission is required by the copyright holder. But this is why CARFAC are very important, because over the last 40 years, they have complemented the Act by recommending fees for the sector. So these are recommended as a minimum fee payment, and we maintain that artists should have the right to negotiate more and more, particularly for larger projects or ones that are more complicated or whatever. With the National Gallery of Canada, the exhibition fees are mandatory. That's a binding legal agreement that we have with the National Gallery. But to be fair, most galleries, or most public galleries and institutions across the country do adhere to exhibition fees. Okay, you can find those exhibition fees in the CARFAC RAV minimum recommended fee schedule. And don't worry, there'll be links at the end. And as you can see, it incrementally increases every year. And there's a whole range of scheduled fees. Typically, you will be offered a scale of payment for a solo show or a retrospective or project work or a single work based on different categories, which take into account the budget of the institution that you're working with. So if it's a smaller place in a perhaps a smaller area of population that doesn't have the reach or budget that another place does, then we understand that they cannot pay you the same amount. But there is that scale available, which you can refer to and which you should be offered. This is just a glimpse or a showcase of what the National Gallery is required to offer, depending on where what space is being used and what type of event it is. So the second one of those is the reproduction right. And it's also provided for in the Copyright Act. And it gives the copyright holder the sole right to reproduce a work or any substantial part of it in any material, and way that CARFAC also offers minimum fee, recommended fee guidelines for these uses. So you can see some of the uses here: digital use of your work, audiovisual, public projections, catalogs, postcards, calendars. All of these are outlined in detail and based on, of course, the volume of production and the time, the amount of time that somebody requires a license for, and so on. But it's all there and documented for you to use. There are other rights to telecommunications, so publication of your work on through television or cable or subscription or or any public telecommunications platform, and you have the right to. It may be more difficult to negotiate, but you do have the right to protect your work in that way. Reprography is if somebody, particularly in academic institutions like your own, photocopying and duplication of work by an artist for research and distribution for research or for teaching, that can be subject to a fee that's paid, a licensing fee that's paid by universities or third level institutions. And if you and you do get a small remittance for that if you register through Access Copyright, which monitors copying on a broad scale. And you can also employ or use a copyright collective to work on your behalf, and I'll tell you more about that later. So I just want to mention the artist's resale right, which is very important. The ARR, or droit de suite, entitles visual artists to receive a royalty each time their work is resold publicly through an auction house or commercial gallery. The AR has been legislated in at least 93 countries worldwide, but not yet in Canada. And what it would mean is that if your work sells on the secondary market, in other words, beyond the initial sale of the work, if it is resold in a commercial gallery or auction house, you would be entitled to 5% of that resale value. And obviously, artists contribute to the ongoing commercial success of their work. As you continue your practice, the value of your work should increase, and you should have a part of that financial stake in that increase in value. Just some examples here. Australia has had the ARR since 2010, and very similarly to Canada, they have similar situations in that a lot of Aboriginal and Torres Strait Islanders artists are the main beneficiaries or a good deal of beneficiaries of that policy. But the UK also has ARR, and you can see that the amount that was paid out benefited a huge amount of artists who then reinvested in their work and practice. One concrete example here, this work by Kanojok Ashevik, which is a well-known image on Canadian postal stamps and things and other places. So you can see it originally sold for $24 when it was created, and resold in 2001 for $58,000, and she would have received $2,933 in royalty payment had that law been in place. So copyright license is an agreement granted by the artist to a user under specific terms. The license should be very specific about what use is being permitted and what fee is to be paid for the use. And keep in mind that generally it is to your financial advantage to set a fee and charge for use of your copyright. It's also generally to your advantage to give permission. And if someone wants to reproduce your work, you should determine the details of that. How many copies are they permitted to make? The reproduction method, the time frame, how long do they want to use it for, and what the cost to them should be. And by limiting the use of it, it allows you to use your copyright again at other times for additional benefits. Oh, sorry, excuse me, one problem again. Okay, so you can assign your copyright and transfer ownership of it. It's not something I'd recommend doing. You have to do it in writing, and you cannot assign your copyright with a verbal agreement. So make sure that you have something in writing. It's always a good idea. You cannot assign or sell your moral rights, and I'll go through what those are in a second, because they relate to copyright. They're held by you, and they're always held by you. If you do decide to assign your copyright, you should state in writing exactly what rights you're assigning, including what is being granted, for how long, similar to what I've just talked about previously. But in general, we don't recommend that you do that unless, and the one instance where it is possible to do, is to assign it to a copyright collective, which then manages your copyright in terms of exhibition, reproduction, and everything for really at no cost to you, and a small administrative fee that is paid by the somebody who wants to use your copyright. So quickly, there are several other rights that are associated with copyright. Your moral rights, the right to claim ownership, the right to remain anonymous or use a pseudonym or pen name or an artist's name, the right of integrity in the case of a work being adapted, modified, or translated. If you feel that the integrity of the work or the meaning of the work has been changed or distorted, that it's prejudicial to the work that you created and you don't like it, then you have that right. You have the right to insist that it isn't used in that way. And the right of association. So if somebody is using it for a cause or in a situation which you disagree with, you have the right to argue that case as well. So just an example of that. This is if you've ever been to the Eaton Centre in Toronto, there's an installation called Flight Stop by Canadian artist Michael Snow, and during one Christmas season, the mall hung red scarves around all of the goose's necks. And Michael Snow complained that this was an infringement on his moral rights, that it was not the intention of the it changed the intention of the work, and he actually won that case, and they had to remove the addition of the scarves from the work. Copyright infringement is something that happens all too often. Civil, you can use civil or criminal penalties. They can be imposed for copyright infringement. In other words, somebody can be required to pay monetary damage, or you can get an injunction or cease infringing. But disputes are generally resolved through direct negotiation, and it is much easier, let me tell you, much easier to protect your work initially and stay on top of things in terms of who's using it than it is to ask somebody to take it down after the fact. That can be really problematic. Some people will agree to it right away. They don't understand the law and they do remove it. But there are many instances in which that doesn't happen, and unless you have a healthy wallet for legal fees, you're going to find it very difficult to deal with. So there are some limitations and exceptions according to fair dealing. So things like parody, satire, criticism, review, news reporting, those sort of things are exempt from infringement. And I didn't go into detail here, but again, our organizations such as CARFAC and Copyright Visual Arts will be able to help you if you don't have all the information in front of you for this. So here's another example of fair dealing. Jeff Koons produced a statue, String of Puppies, which was, as you can see, quite literally based on a photograph of a couple who raise puppies and have a business doing so, and they argued that it was prejudicial to their business, and that it was that they weren't given any that it was literally copied. There was not enough variation in the work, and they in fact won this case against Jeff Koons. So there is one sort of exception to your ownership of copyright, and that is since 2012, the rights of the photographer. Now, if the photographer is an employee of an institution, of the institution, and the employment contract does not specify anything contrary to that, the owner of the copyright is the institution. But if you, as an individual, hire a photographer to photograph your work, for instance, the owner of the copyright of that photograph is the photographer, unless specified otherwise in the contract. This is why it's a sticky area. Now, most photographers are fantastic about this. They're very aware that why you're photographing your work, but it is important to realize that in the letter of the law, they could and they do hold the copyright. So you can get around that by specifying it when you hire somebody that they do not own, that you maintain the copyright of the art of the work. The artist, the photographer, is still getting paid, or whatever deal you have with them, but it's important to realize that under the letter of the law, you need to spell that out in your contract. When using a photograph provided by an artist, make sure to clarify who owns the rights of the photo and consider using a contract. So there you go. And always credit the photographer. I mean, I'm sure we've all been in a situation where somebody has, I know somebody has taken a photograph of me in my studio, which I've later used in terms of on my website or in some kind of publication or other. And I've always been very careful to credit my friend or colleague who's taken that photograph, or in fact to pay for it if it's a professional photographer. This is an example of how I would might add a label to a piece of my work. You would start with the title, the medium, the size, the date of creation, and if I'd taken the photograph, then there's perhaps no need to put the photo credit in there. But in this case, my gallery, the gallery that represents me, may have taken the photograph, and I would credit them as having taken the photograph, or if it was an individual, I would credit them there. This is also this is an example of my work where there are various components to it. It's sculptural, an installation, but it also has a video portion to it, component to it, which I actually hired a filmmaker to assist me with. Under my direction, he did the filming and we worked on the editing together. So in this case, I didn't feel the need to under the contract that we had to give him credit for the work. But I did acknowledge the filmmaker separately for his contribution, but not as an author of the work. So that he wouldn't have been mentioned on the label for the work, but I would have in fact have acknowledged his contribution. So here's a checklist. If you're using someone else's copyright, determine who is the copyright owner and seek permission for the use before you use it. Don't assume things. Make sure you've checked and sought permission. License or buy only what you need. And clear the rights in advance and complete all permissions, contracts, and licenses. If someone wants to use your copyright, any arrangements you make regarding your copyright should be in writing. Use an agreement for sales or donations of artwork that include a copyright notice. And when you give permission to someone else for the use of your copyright, you should be very specific about what you're allowing them to do. Are you allowing them to simply reproduce the work in an article that they're writing? Are you allowing them to produce 500 postcards, which they're going to sell or give away? There's all sorts of examples, but make sure you're specific. So there are organizations out here that can help you. I mentioned Copyright Visual Arts. This is just a screenshot of their webpage, their website. They are an organization run by CARFAC and RAV, which is our sister association in Quebec, that will administer your copyright for use for users if you have an agreement with them. It doesn't cost you any money. They also have an image bank which will support your work. Very good organization. And just thought I'd mention something that's on their page. They have sort of a Copyright 101, which may answer some of the questions that I haven't answered here, perhaps, or reinforce the ideas about them. And there's some articles there. 5 Dumb Myths About Copyright is a very good one. Generally different ways, and they're very helpful if you want to reach out to them. And lastly, some resources which I'll run through very briefly. I mentioned CARFAC. There's regional offices. CARFAC Alberta obviously is your contact. But there's a national office. There's also one in every province. The minimum fee schedule, the CARFAC RAV minimum fee schedule is there. Copyright Visual Arts, CARFAC Alberta. Something I should mention is a very useful tool with CARFAC Alberta. They have published best practices for craft media and visual artists. There's a series of 7 documents, I think, which relate to selling your work, contracts, doing a public art commission, all sorts of different things that you can, and they walk you step by step through what you should expect and how to protect yourself, and how to be professional about it. Access Copyright is a big defender of copyright for artists, authors, illustrators in Canada. And there's various others there if you really want to take a deep dive into it. So I think that is it. I'm just going to stop sharing my screen. And I would gladly take questions if there are any. I'm just looking through the chat.
Thank you so much, Patty, for doing this presentation and for getting through all the technical issues. So thank you so much in advance for that. And yeah, let's open up the floor to questions. Feel free to just unmute yourself and talk, or you can feel free to use the meeting chat as well. Okay, I have a question from Maria. So she's asking, to use a photo on a museum site, do you need permission? For example, when the artist is over, like it's past 50 years of death.
No, you shouldn't. You shouldn't need permission. Presumably, yeah, it's. I think there's still degrees of right and wrong in this. I think you're perfectly entitled to use it for reference, to illustrate something, to embellish something. You should credit, of course, the institution which you got the image from. The difference, I guess, depends on whether you're using it for profit or not. So there's certainly, it's perfectly acceptable to use it in many ways. If you're taking any image of it from anywhere and then using it for profit, it's a little bit less ethical, I would suggest.
So I do want to put you on the spot here just a little bit, Patty, because I know that you and I talked a little bit before this presentation about a specific sub-industry of visual arts, which is fan art. And I know that some of our students within the school do make fan art or are very much inspired by not just historical artwork, but contemporary artwork, such as, you know, characters and scenes and whatnot from Disney, DreamWorks, Studio Ghibli. And while fan art is a way for artists to generate an income, and it is in some areas like recognized as kind of its own as its own thing, what do you think kind of from a copyright standpoint, especially in terms of commercial sale, do you think that there is some if you wish to identify, you know, what is fan art and what do you think is removed far enough from the original design that, you know, artists might be more comfortable in selling it or, you know, making it, just because, you know, most often the copyright in question is often those of very much larger companies, internationally renowned stories and artworks, and so it can get a little bit difficult there, right?
Yes. Well, you mentioned something there that I think really doesn't makes fan art not that different from anybody else, and that is the amount to which you are literally copying any particular work. So I would be careful and cautious about you know, simply incorporating images that were created by somebody else, especially organizations like Disney, which are ruthless at going after anybody for copyright infringement. So I think it's a matter of degree. I don't see anything that you know. It really depends on how you use it. I'm not afraid I'm not up on my fan art, but it depends on how much of the original you know, what percentage of that original is incorporated into your work. Is it just you know, is it one character that you're adding to a whole collage of characters in some other composition, or is it part of that character? Is it or are you altering it in some way, but using it as inspiration? I think you have to be very careful with these large corporations because they are highly protective of any use of their work. Particularly, as I mentioned, Disney. I'm not sure what Ghibli is like or anything, but I don't think it should deter you entirely from using it as a reference or as impetus. But you may want to seek further advice from somebody more specialized in that field before. And again, this is what I would really emphasize is do your research and you know, find out. All this stuff is available somewhere. Find out what is acceptable, and generally, if you ask people, especially creators, they are helpful. But what they're not, what they dislike, is people making assumptions and using their work without permission.
Awesome, thanks. And we do have another question from Maria in the chat. So how does it work in the case of collage art? What are the rules? For example, magazine images, celebrity images.
Those are generally, well, magazine images are generally, you know, especially if you're just using a portion of it in collage, they are generally in the public domain, I think, and are acceptable because you're not really using them for the same intent that they were created for. I would, always, again, try and reference your sources. But I mean, that goes back a long way. Collage has been used, it's a fundamental part of art practices for many, many, many generations. So I think, again, with all the preparation and due diligence that I mentioned, that I wouldn't be overly worried about that.
Any other questions? All right, I think then we're good for this workshop. Thank you, everybody, for joining us today, and for being patient while we work through our technical issues. We appreciate it. As Patty said before, the recording will be up on Microsoft Stream as soon as we get it downloaded and edited a little bit. And we will also have the presentation available, and both of these resources will be available until the end of the academic year, which is in 2022. And because also, as the SA, we do want to acknowledge and respect other people's copyright, we are doing so by making this, a limited run. So thank you, Patty, so much for allowing us the rights to distribute up until the end of the academic year. We know that like your teaching and the knowledge that you have is very, very valuable. So we really appreciate you making that concession for us and our school and our students.
No problem. And thank you very much for inviting me. And I would, I just would close by saying, if you have any questions that occur to you later, you can get hold of me through Leah, or get hold of CARFAC, amazing organization that they're only too glad to help you out with any problems you have.
Awesome. Well, have a great day, everybody. Thank you to everyone who came, and we hope you have a great afternoon.
Thank you, everybody. Bye.